John as Chair and members of the Queensland Sentencing Advisory Council and the Secretariat, authors of the Council's paper, Engendering Justice, the Sentencing of Women and Girls in Queensland, former members of the Women's Safety and Justice Taskforce and Secretariat, distinguished guests, as you all are, for supporting the work of these wonderful, clever and underappreciated people. I too warmly and respectfully acknowledge the traditional owners of this land, the Turrbal and Jagera peoples and their elders past and present. They prospered here, living lightly on this bountiful country beside Maiwar, as this stretch of the Brisbane River was known. For tens of thousands of years before European settlement, they had held gatherings to discuss ways to do things better in their communities. In speaking tonight, I'm inspired by and honoured to be part of that ancient tradition. I'm also pleased that Australia is at last moving towards accepting the Uluru Statement from the Heart request for recognition in the Constitution of Australia of a First Nations voice to Parliament. After almost 50 years, as John reminded us all, of working in the criminal justice system in various roles, paralegal, barrister, trial and then appellate judge and royal commissioner, I came to learn a bit about sentencing. Although I was conscious that as a woman working in these fields I was helping change gender stereotypes, I did not consider that it was prudent or even necessary to take a gendered approach to sentencing. In the 1970s, women and girls charged with criminal offences in the higher courts were, like women barristers, something of a rarity. There were no Queensland women judicial officers until 1990, and they still remain a minority. Like most involved in the criminal justice system, I understood that the rule of law required women and men, boys and girls, to be subject to the law, which was not gendered. Comparable sentences imposed on offenders of one gender might be relevant to sentences imposed on another gender, at least as far as they were comparable. But I certainly understood that women and men, girls and boys, are different, they have different life experiences, and the factors relevant for judges determining their sentences are different. But I did not think these different sentences turned on the offender's gender, but on the applicable law, the individual circumstances of each offender relevant to their offending, to their insight into their offending, and to their prospects of rehabilitation. Fortunately, our understanding of gender issues has improved since the 1970s, and exponentially in the last 5 years. Fast forward to 2017 and the viral international spread of the #MeToo movement, calling out and demanding accountability for perpetrators of sexual assault and harassment. Thanks to the advocacy of domestic and family violence support organisations, the public has steadily grown increasingly concerned about the high rate of domestic violence killings. The horrific premeditated execution of Hannah Clark and her 3 children in their car on the streets of suburban Brisbane in February 2020 caused national community outrage. In October 2020, investigative journalist Louise Milligan published Witness, a blistering critique of how the adversarial criminal justice system in Australia further traumatises victims of sexual assault and highlighting the need for change. In January 2021, Grace Tame was named Australian of the Year for so powerfully advocating for the rights of survivors of sexual assault. The allegations of Brittany Higgins and others revealed a toxic, misogynistic culture within the Australian Parliament in desperate need of reform. Australian women had had enough. In March 2021, Grace Tame led Hobart's March for Justice, with similar marches across the nation, calling for equality, justice and an end to gendered violence. Little wonder then that on the first anniversary of the domestic violence killing of Hannah Clark and her children in 2021, the Queensland Government set up the Women's Safety and Justice Taskforce. Though we're still catching my breath from a gruelling 2-year Victorian Royal Commission into the management of police informers, when Attorney General Fetterman invited me to chair this consultative and independent task force, I was honoured to accept. Although without precedent, it presented a vitally important, timely and for me irresistible challenge. The name of the task force and its terms of reference, which were drafted by the government, not the task force, were gendered, essentially requiring us to do two pieces of work. The first was to report on the best legislative model against coercive control and whether domestic violence should be a standalone criminal offence. The Taskforce completed this aspect of its work with the report Hear Her Voice 1 delivered to government at the end of last year. In May this year, the government supported in principle all 89 of that report's recommendations. The second part of our work was of much broader scope to examine the experience of women across the criminal justice system, including as girls and as offenders. Given our short timeframes for reporting and our extremely finite resources, with the help of community consultation, we refined the focus to women and girls' experience in the criminal justice system as victim survivors of sexual violence and as accused persons and offenders. We delivered Hear Her Voice 2 with its 188 recommendations to government on 1 July this year. The government has not yet provided its response to that report. Despite the gendered nature of the Taskforce's work, some members, me included, appreciated the difficulty in taking a gendered approach to these issues. To do so ignored the experiences of members of the vibrant LGBTQIA+ community, a group who are too often victims of domestic and family violence, including coercive control and sexual assault, and for whom the experience of the criminal justice system, whether as victim survivor or offender, is often traumatising and even dangerous. We were also conscious that men and boys and the non-binary can be victims of coercive control, domestic and family violence and sexual assault, and that violence is sometimes perpetrated by women or girls. And we understood that many of the issues which influenced women to become offenders and hindered their rehabilitation could also apply to men. On the other hand, the overwhelming number of victims of domestic and family violence and of sexual assault are women. Almost all women offenders are victims of abuse, and most are affected by their role as mothers or carers. In any case, the Taskforce had gendered terms, and this work clearly needed urgent attention. We noted our concerns at the beginning of each of our reports, and then, as required by our terms of reference, took a gendered approach to our work. Given the Hear Her Voice 2 report and recommendations, it was hardly surprising that John Robertson and Ava Klambauer suggested I speak this evening about why a gendered approach is needed when sentencing women. I think I have, or hope I have, a reputation for an independent spirit. So true to form, I've added a question mark to the title of the speech tonight. Engendered Justice, ? I'll explore that question mark in this presentation. You would be wrong to think that only that part of our report and recommendations dealing with women and girls as offenders is relevant to tonight's discussion. I read around 500 submissions from victim survivors of domestic and family violence and 250 submissions from victims of sexual assault, with 125 of those submissions being from victims of both forms of abuse. Although a few submissions were from men and LGBTQIA+ people, overwhelmingly they were from women, including First Nations women, older women and girls. I also read 19 submissions from women who had been imprisoned, as well as submissions from those who guarded or assisted them. I had hundreds of consultations across the state, from the Torres Strait, the Northern Peninsula area in Cape York, Cairns, Yarrabah, Townsville, Palm Island, Mackay, Woorabinda, Rockhampton, Toowoomba, the Sunshine and Gold Coast, Cherbourg and the Brisbane metropolitan area, with stakeholders including the judiciary, legislators, senior policymakers and academic experts, victim survivors, former incarcerated women and those who support them, and whistleblowers. I also visited women, girls and corrective services and youth justice officers in Townsville and Gatton prisons and in the Cleveland Youth Detention Centre. I learnt so much of it very confronting. Safe and secure housing is a basic human need, but wherever I travelled in Queensland with the Taskforce, examining the experiences of Queensland women and girls in the criminal justice system, I heard of the high cost and lack of availability of basic housing. The detrimental impact of this housing shortage is falling disproportionately on the most vulnerable, women victims of domestic, family and sexual violence and their children, including incarcerated or recently incarcerated women. Australians, on average, are now the fourth richest people in the world, but the richest 10% of households owns 46% of all Australian wealth, while the poorest 60% of Australian household own just 17% of that wealth. Wealth inequality rose sharply between 2003 and 2018, then declined slightly. Unfortunately, this small decline in wealth inequality only reflects that those who bought houses before the most recent property boom have become wealthier, with the gap between the poor who do not own property further widening. Without exaggeration, there is a housing crisis in Queensland. Many women victim survivors of domestic, family and sexual assault and their children are returning to unsafe living circumstances because they have nowhere else to go. These courageous women who refuse to return to abusive partners are living with their children in poverty, in unsuitable short-term housing, such as poor quality, unsafe motel rooms. In rural, regional and remote areas, support workers are also affected. They're unable to deliver vital programs to keep women victim survivors and their children safe and hold perpetrators to account because support workers cannot relocate without suitable accommodation. If confirmation be needed, Anne Sumner's recent report, The Choice, Violence or Poverty, Domestic Violence and its Consequences in Australia Today, also powerfully illustrates the devastating impact of domestic violence on women, their children and our communities throughout the nation. What, you might ask, has this to do with women sentenced for offences? Plenty. In my work with the Taskforce, I learnt that almost all Queensland women prisoners are victims of domestic, family and or sexual violence, and they are often victims of multiple forms of violence. Although women commit far fewer and much less serious offences than men, the number of women in Queensland prisons is growing at 4 times the rate of male prisoners. Concerningly, the number of women in Queensland prisons is proportionately higher than in other states. Recent reports from the Queensland Productivity Commission and the Australian Productivity Commission have questioned the economic and social wisdom of continuing to imprison more people and build more prisons. Prisons are expensive and they are not effective in reducing recidivism or keeping the community safe. The cost of imprisonment is over $120,000 a year per prisoner. While some offenders are a danger to the community unless incarcerated, there are a small minority. These are a small minority. For most prisoners, supporting them so that they do not offend in the first place or assisting them to rehabilitate outside prison is far more cost-effective and much more likely to reduce crime and keep the community safe. I was surprised and shocked to learn that when people are imprisoned in Australia, they lose their entitlement to Medicare and to most of their National Disability Insurance Scheme benefits, with all care responsibility handed over to the state governments. Most prisoners have physical and mental health illnesses when they enter detention, and many have disabilities, often undiagnosed. Imprisonment provides an opportunity to address these concerns, which are likely to have contributed to their offending and to hinder their successful rehabilitation in the community. Yet the Taskforce identified worrying gaps in prison health care, including in addressing the significant detrimental mental health effects of the trauma women prisoners have experienced prior to their offending. Women in prison, those who had recently left prison, and those who supported these women told me about the inadequate pre- and postnatal care and birthing assistance in Queensland prisons. I heard so many heart-wrenching stories. This poor quality healthcare risks condemning innocent newborns to an inherited cycle of poverty and dysfunction. And I was dismayed to learn that there were few suitable education and rehabilitation programs to help incarcerated women achieve and maintain a crime-free, pro-social life once released into the community. My work with the Taskforce also highlighted homelessness and poverty as significant causative factors in women and girls committing offences in the first place. These same factors mean that women without housing, charged with offences, are spending longer in custody, as without a stable place to live, they're unable to persuade the courts to grant them bail. And I was shocked, but no longer surprised, to hear from the parole board that women in custody who are otherwise eligible for parole are remaining in prison because no one can find them even a single room anywhere in Queensland to live. These problems are magnified for women from culturally and linguistically diverse backgrounds, for those with intellectual disability, and particularly for our First Nations women. These vulnerable cohorts of women are especially prone to misidentification by police as perpetrators of violence, when a thorough examination of the whole relationship between the parties over time would often reveal that the women were the true victims, reacting to a long history of abusive violence and control. First Nations women and girls are disproportionately represented as offenders. They make up only 4.6% of the Queensland population aged 10 and above, but 31.1% of females sentenced in Queensland between 2005 and 2020 were Aboriginal or Torres Strait Islander. It is concerning that between 2012 and 2021, the number of women in Queensland prisons overall has increased exponentially by 80.3%. It is even more concerning that the number of First Nations women in prison has increased by an astounding 120.5%. First Nations women in custody are suffering not only the effects of trauma as victim survivors of multiple types of domestic, family and sexual violence, but also the impacts of intergenerational trauma arising from colonisation, including the stolen generations. Many of these women live in remote First Nations communities where services and supports are very limited. Poor internet access means that even the virtual delivery of programs, training and support is at best difficult and problematic, and at worst impossible. We have learnt during this pandemic that although imperfect, virtual services can be delivered remotely. Adequate internet connectivity is essential to delivering the services women and girls need living in remote, rural and regional Queensland. And to effect positive change in First Nations communities, problems must be recognised and the solutions led and delivered by those within these communities. We discovered excellent First Nations-led trauma-informed rehabilitative programs that should become templates for mainstream programs. In Hear Her Voice 2, the Taskforce makes 84 recommendations about women and girls as offenders. The recommendations are based on a public health and justice reinvestment process with a much-needed focus on First Nations peoples. They include trauma-informed responses to women and girl offenders who have been victims of violence from all involved in the criminal justice system. More options to support offenders so that they do not enter the criminal justice system. Better education and rehabilitation programs. More non-custodial community-based sentencing options. A wider use of pre-sentence reports, and decriminalising offences that are health issues like possession of unlawful drugs and drunkenness. I thank the Sentencing Advisory Council for the generous assistance it provided the Taskforce, even allowing us early access to some important statistics in an early draft of the paper being launched tonight in all its final edited glory. I also thank the Council for supporting, and Laura Hidderley, Samuel Jeffs, Dimity Toms and Dr. Ava Klambauer for writing Engendering Justice, Current Trends in Sentencing Women and Girls in Offenders. Whereas the Taskforce was consultative, giving voice to those who were voiceless, the victim survivors of domestic, family and sexual violence and incarcerated women, by contrast, the paper collates and interprets recent data and statistics, providing the critical evidence essential to formulating and delivering sound policy in a controversial area and one generally without electoral appeal. And I really congratulate the media who has today taken up this issue and reported so fairly and so thoroughly on it. I think that's a wonderful start to us as a community addressing this huge problem. I confess to being relieved when I read the paper that nothing I learnt through my Taskforce work or put in the report and recommendations was gainsaid by the information in the paper. That was a great relief. And in fact, the Taskforce reports and recommendations are supported by the carefully researched evidence in the paper. For example, the paper notes that women and girls in remote areas have a higher number of recidivist offences than women and girls in major cities. This collates with the paucity of programs in rural and remote areas highlighted in the Taskforce recommendations, including for sentenced women and girl victims of domestic, family and sexual violence, who, if adequately supported, may not have offended at all. The paper highlights that women most frequently reoffend for breach of bail and for contravening domestic violence orders or directions of a police officer. As the Taskforce discusses in its report, women may breach bail because of their caregiving responsibilities, because they become homeless, or because they are experiencing violence from a partner. The attitudes of some police officers who misidentify as perpetrators women who do not fit the traditional victim model, or who over-police these women, may well explain the high female charge rates for contravening domestic violence orders and directions of police officers. I was interested to read the paper's statistical proof debunking the myth that women are sentenced more leniently than men. In fact, the paper notes that when women commit serious offences, they're sometimes dealt with more harshly than men because of their unwomanly conduct, something I also heard directly from incarcerated women. The paper provides unequivocal statistical proof of the steep rise in incarcerated women in Queensland noted by the Taskforce. The paper refers to the concerning rise in short prison sentences for women, with over 40% being for less than 6 months and almost 27% being for less than 12 months, and with these sentences, short as they are, getting longer. Almost all these sentences are imposed in the Magistrates' Court. This is so even though fewer women are being sentenced overall. There is a great deal of research, including from the Council, about the undesirability and futility of short prison sentences. As the Taskforce noted, these short sentences cause enormous disruption to the lives of women and their children, often leading to homelessness and children moving into state care, making innocent children more vulnerable to themselves entering the criminal justice system. Indeed, the sentencing of girls to detention has more than tripled since 2005, again with most of those sentences imposed in the Children's Court at Magistrates' Court level. The high numbers of girls aged 12 to 15 years entering the criminal justice system, the paper contends, suggest a need for gendered and early approach to prevention. This all demonstrates that judicial officers need more supported community-based sentencing options addressing the cause of the criminal behaviour for those minor offenders who repeatedly reoffend after being sentenced to non-custodial orders. Adequate funding for timely merit-based appeals from these inappropriate short sentences and for applications for bail pending appeal is also needed. I was interested to learn from the paper that statistically First Nations and non-Indigenous women tend to commit different types of offences. First Nations women are primarily arrested for public nuisance, contravening a direction of a police officer and breach of bail, with these comparatively minor offences often resulting in imprisonment. Non-Indigenous women are mostly charged with possession of dangerous drugs or utensils and shoplifting. The Taskforce has made recommendations that, if accepted, will lead to the decriminalisation of many of these offences. The paper also confirms what I heard firsthand, that for women in custody, separation from their children is a major stressor for both mother and child. Like the Taskforce, the paper highlights limitations caused by gaps in data collection and the intersecting vulnerability, disadvantage and marginalisation, particularly for First Nations women, caused by unstable housing, trauma, mental health, substance abuse, caring responsibilities and involvement in the child protection system. It notes that over 85% of incarcerated First Nations women have cognitive, mental health and or substance abuse issues and that over 25% of incarcerated women overall suffer chronic medical conditions or disability. This shows the stark need for increased investment in health services for incarcerated women. The paper confirms the shameful overrepresentation in Queensland of a First Nation incarcerated women and girls. As noted earlier, the Taskforce identified in its reports that in part this is the legacy of Australia's colonial history and resulting intergenerational trauma, including from the stolen generations. Since the Taskforce completed its work, Prime Minister Anthony Albanese has revived the issue of constitutional recognition of a First Nations voice to Parliament. The 16-member Referendum Council, established by Prime Minister Malcolm Turnbull in 2015, travelled around Australia and consulted with over 1,200 people before conducting the 4-day First Nations National Constitutional Convention near Uluru in Central Australia. On 26 May 2017, the more than 250 convention delegates issued the Uluru Statement from the Heart, a petition from First Nations leaders to amend the Constitution of Australia to enshrine a First Nations voice. On 30 July 2022, Prime Minister Albanese announced his government's support for a referendum to amend the Constitution to provide an Aboriginal and Torres Strait Islander voice to make representations to Parliament and the Executive Government on matters relating to First Nations people. While constitutional referenda in Australia are seldom successful, there are promising signs that despite the Turnbull government's rejection of the notion, there is popular support for this change, including now from Malcolm Turnbull, I heard on 7:30 last night, and perhaps even bipartisan support. Some, including some First Nations leaders, have rejected the move as mere symbolism, saying actions, not words, are needed. It's abundantly obvious that evidence-based First Nations-led policy resulting in practical improvements in the lives of First Nations peoples is urgently needed. The paper, like the Taskforce, identifies the alarming growth in numbers of incarcerated First Nations women and the urgent need for the Queensland Government to meet its commitment to the Closing the Gap targets to reduce the overrepresentation of First Nations adults and children in the criminal justice system. This must unquestionably be a priority. But it is also essential that Australia's Constitution at last appropriately recognises the nation's original inhabitants. In fact, constitutional recognition is likely a crucial prerequisite to achieving lasting positive change in reducing First Nations peoples' overrepresentation in prison and improving their health and education outcomes. That is because words, respect and recognition matter. We all love to be loved and valued. As the Statement from the Heart explains, when First Nations history and culture are respectfully recognised and their people given a real voice in Australia, their children will flourish, they will walk in two worlds, and their culture will be a gift to their country. And I'm confident that their numbers incarcerated in prisons will also reduce. Returning to the question of whether the criminal justice and corrective systems should take a gendered approach to sentencing, the statistics and the author's analysis of them in this paper provide powerful evidence of the need for a gendered approach to sentencing insofar as everyone working within those systems, including policymakers, should understand that sentenced women and girls are highly likely to be victims of past trauma and with multiple other intersecting disadvantages. Sentencing mothers to prison, even for a short time, particularly for a short time, will likely cause harmful disruption to the family unit, unfairly punishing children and putting them at risk of criminalisation. Short sentences should be avoided wherever possible. More support is needed to stop women and girls offending in the first place. For those who do offend, more options and support are needed to keep them out of the criminal justice system where possible and to reduce their numbers on remand. For those who are sentenced, more non-custodial community-supported sentencing options are needed. For those who are incarcerated, more rehabilitative support is needed to help address the trauma contributing to their offending, prepare them for their return to the community, and adequately support them after release to avoid recidivism. Those working within these systems, including sentencing magistrates and judges, need to understand the dynamics and effect of sexual and domestic and family violence, including coercive control on victims, and the importance of examining the whole relationship over time to avoid misidentifying the real perpetrator. As noted earlier, sentenced men and boys, LGBTQIA+ people and the non-binary may also be victims of trauma and intersectional disadvantage, requiring an appropriate criminal justice and corrective systems response. But that was not the subject of my task force or this paper. Taking a systemic, engendered approach to the sentencing of women and girls does not mean that they will all routinely be sentenced more leniently or in a certain way that is not available to men and boys, LGBTQIA+ people or the non-binary. It means those within the justice and rehabilitation systems understand gendered issues, such as that domestic, family and sexual abuse predominantly affects women and girls, the common detrimental impact of sentencing mothers and carers to imprisonment, and that sentenced women and girls are likely to have been victims of violence with the resulting trauma relevant to their past offending and future rehabilitation. These matters, however, will only mitigate a sentence where the sentencing judge or magistrate accepts they have relevance in that particular case. As the Council's paper, and I hope the Task Force recommendations identify, an engendered justice response to sentencing means nuanced, individually tailored, gender-specific and more effective criminal justice and rehabilitative responses. In that sense, I enthusiastically endorse an engendered justice approach to the sentencing of women and girls. My conclusion, the question mark in the title of this presentation, Engendered Justice, should be removed. Congratulations to the Council for supporting the research for and publication of this paper and to its talented authors. As they identify, it provides invaluable statistical insights and an evidence-based foundation for further research and for much-needed policy development to reduce women and girls offending. This paper will support reintegration into the community for those women and girls who do offend, reduce their incarceration rates and recidivism, and help keep the community safe in a more effective, less costly way. Thank you.